Hello, my name is Michael Teixeira and I've prepared this presentation entitled Federal Court Employsure Ping Pong Match Game Over. And the reason I've called it this is because it was a strange sort of case where the primary judge would make particular decisions and they would be appealed to the federal court, who would reverse those decisions and then remitted back to the primary judge, who would make further decisions which were then appealed and reversed again. So it's been a bit of a ping pong match, I think, and finally it's been game over. There's some Employsure closure as a result of the recent full federal court decision. Bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice to say legal consulting for the last 15 years, and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as a director of enforcement. Now, the background to the case, there's quite a lot to cover. I'll start with a bit of background and then discuss the first instance liability decision of Justice Griffith, then the full court decision, which effectively reversed Justice Griffith's decision on liability. Then I'll look at the first instance decision on penalty and costs. There are two decisions there, and that was also by Justice Griffith. And then the appeal against both the penalty and costs decision, which were both reversed by the full federal court. And then I'll finish with some commentary. Now, the background to the case, ACCC initially commenced 5 separate actions against Employsure for its advertising, and the first was a government affiliation representation, which occurred through various Google ads, which the ACCC claimed represented to consumers, business consumers, that Employsure was affiliated with or endorsed by a government agency. And those government agencies were the Fair Work Ombudsman and the Fair Work Commission. The second allegation sort of relates to the first one, but it's an allegation that Employsure used keywords and designed its ads to mislead consumers as to their association with those two government organisations. The third was an allegation that the way Employsure offered this free helpline was driven or had the primary function of actually trying to sign customers up to paid services from Employsure. So alleged that was misleading. The fourth allegation related to unconscionable conduct. In this regard, the ACCC put forward 3 business consumers to demonstrate unconscionable conduct. And the final was some allegations that the standard form contracts used by Employsure contained unfair contract terms. Now, there's an example of the advertisements at issue in this case. You can see the first one refers to Fair Work Australia, free fair work advice, all in very prominent coloured writing. And I guess you see there the encouragement to call now to get this free advice. And the second ad, Fair Work Ombudsman help, so sounds a bit like you'll be getting help from a government department. Free 24/7 employer advice, so again the idea of free advice. And I guess the notable omission from these advertisements is there's no reference to Employsure as the company behind these 2 advertisements. Now, a key issue for Griffith in coming to his initial decision was how impressed he was with Mr. Mallet, who was the managing director of Employsure at the relevant time. And as you can see there, he concluded he was an impressive witness. He gave his evidence thoughtfully, honestly. He was also very responsive to his searching cross-examination. But then he's talking about the fact that the evidence given by Mr. Mallet concerned the reasons why Employsure selected particular keywords and designed the Google ads in the way they did, and furthermore that based on Mr. Mallet's evidence, he was satisfied that Employsure had not been had the intention of misleading consumers by their advertisements. So at this stage, you're seeing a strange approach being taken by the judge, where he's focusing very much on the intention of Employsure as manifested through its managing director, which is really not the way to approach a misrepresentation under the Australian consumer law. Really, you've got to look at the advertisement, the representation objectively, and try to understand the way consumers would have understood that particular representation. It's not a case of trying to determine the intention of the parties in making the representations. And the other thing you can see at the end there was he relied on Mr. Mallett's evidence to conclude that all the standard form contracts terms which the ACCC believed were unfair were actually required to protect the legitimate commercial interests. Now, in relation to the government affiliation representations, Justice Griffith concluded that they were not misleading when viewed through the prism of a reasonable member of the relevant class. And that's a very key issue, the way he defined the relevant class. And he also believed the fact that the vast majority of consumers who saw the ads and did not click on them was very strong evidence that they were not led into error, and accordingly it was not misleading. And I don't think that's a way that the courts have generally sought to interpret the misleading deceptive provisions of the Act. Pointing to individuals and trying to work out whether they're misled or not really is an objective assessment of the advertisement which the judge is supposed to undertake. Now, in relation to the second allegation, which was in relation to the keywords and design representations, the judge said there that the ACCC bore the onus of establishing that Employsure deliberately used keywords associated with government agencies as part of its design. And I put the word deliberately in red there because actually in the judgment it's in bold. And so the judge is drawing attention to the word deliberately. And initially you may think that, well, that's not an element of misleading deceptive conduct provisions. However, what the judge is getting at there is that the ACCC in its pleading actually stated that Employsure had deliberately used keywords associated with government agencies. So that meant the ACCC had the onus of showing this deliberate nature of their conduct or intentional nature of their conduct. So I think that was a mistake in the pleadings. You probably shouldn't have included the word deliberately in those particular pleadings, and I think Justice Griffith was correct in concluding that the ACCC had failed to show that deliberate nature. Now, the free advice representations, I think the judge was very critical of this particular part of the ACCC's case, because what he's saying there is that clearly offering a free service is what business is all about. It's a way of getting the attention of a consumer and then making a pitch for paid work. And as you can see, the second quote, he says, no reasonable business owner could expect that Employsure would be incurring the cost of providing this free helpline unless they were motivated by a desire to secure new leads for the business. So they're actually trying to generate paid business. And he concludes that effectively the ACCC's submission on this particular issue is divorced from commercial reality. The next allegation relates to unconscionable conduct, and as I said earlier, there were 3 witnesses put forward, and what the approach that Griffith took to this was very fact specific. He looked at each business consumer and looked at their circumstances and the interactions they'd had with Employsure, and he firstly concluded there was no evidence they were suffering from a special disadvantage. Secondly, he was quite persuaded by the fact that even if the consumers had been misled initially by the representations, they discovered the truth after the initial contact. So they discovered that Employsure was behind the advertisements, that it was offering a paid service as well, in addition to the free service. Also, Griffith found that customers were fairly capable, sophisticated business people, so not the kind of people that could be taken advantage of. And finally, there was some evidentiary inconsistency. So statements were put on by these witnesses, and that was compared to the actual recordings of the communications between the consumer and Employsure, and there were some differences. So based on all that, the Justice Griffith rejected the unconscionable conduct claim in its entirety. Then finally, with the unfair contract term allegation, the judge concluded, I guess, firstly, that the terms weren't unfair, but even if they were unfair, he believed that effectively the defence, which applies on legislation, was made out. So Employsure made out that the terms were necessary to protect its legitimate interests. He also concluded they were undeniably transparent. Furthermore, that they were in plain English, they were not incoherent or incomprehensible. So they ticked all the boxes in terms of not being an unfair contract term. But the thing that was a bit concerning was that quote there towards the end, where he says none of the impugned terms would have caught any consumer by surprise, assuming that the consumer took the time properly to understand and reflect upon the provisions, as they reasonably ought to have done prior to entering into a legally binding contract. So what he's saying there is if you sign an agreement, you're bound by the terms, which goes entirely against the whole purpose of the unfair contract term laws. It's based on this take it or leave it type agreements or contracts of adhesion, where consumers, business consumers included, rarely read all the terms. And the legislation is protective legislation. It's seeking to identify terms which are unfair and at the moment render them void. In the future, they're going to be illegal. So here he's reflecting, I guess, a misunderstanding of what the unfair contract term laws are all about. So he rejected the ACCC's case in its entirety, and there was an appeal to the full federal court, and it went before Rares, Murphy and Abraham. And as you can see, the ACCC only appealed on the government affiliation representations case, which they allege breached Section 18. Also 29(1)(b), which is a representation that services are of a particular quality. So the idea there that government services are of a higher quality in consumers' minds that may be a private service. And finally, that the Employsure had made misrepresentations about government sponsorship and approval. So as you can see, they didn't appeal the keyword design case, the free representation case, the unconscionable conduct case, or the unfair contract terms allegations. Now, the ACCC's case was looked at by the full federal court, and they concluded immediately that the learned primary judge had erred in failing to find that the Google ads were misleading, deceptive in the sense that they made this government affiliation representation, and an ordinary reasonable member of the class of consumers would have been misled by these representations. Also, they were critical of the way the judge approached the characterisation of the ordinary and reasonable business person. They believe that he accorded that particular business person a too high a level of shrewdness or wariness and digital literacy and commercial sophistication. He also set a very high standard as to the level of attention and scrutiny that members of this class were likely to give to an advertisement. So effectively, he had set a very high standard and said that that was what consumers who saw the ads should be expected to do. And really, that wasn't the right approach to take. In actual fact, it was quite different to a lot of earlier cases which looked at the relevant class of people and the level of sophistication they're expected to have. Also, the conclusion of the full federal court is that it's not unreasonable for consumers, including business consumers, to give perfunctory attention to advertisements, and particularly where the advertisement is trying to trigger immediate interest in the offer by offering free advice. So when there's this offer of free advice, many consumers, including business consumers, will respond to the call to action by immediately clicking the hyperlink or calling the phone number. So that's a very relevant factor, the fact that there was an offer of free advice. So they concluded that it was not unreasonable for an ordinary consumer not to read the advertisements closely. In actual fact, it's expected that such consumers may read these advertisements quite fleetingly. They're busy people and only absorb their general thrust. And this idea, and this is based on a lot of authorities, is that this fleetingness of attention is going to be even more fleeting given there's an offer of free advice. So clearly, as I said at the end there, the degree of attention and scrutiny likely to be paid to an advertisement will in part be a reflection of the cost of the goods or services. So if a good's offered as free, people are not going to be reading that advertisement in an incredibly concentrated way. They also looked at the category of people, and they believed the primary judge had sort of excluded groups of individuals from the group that should be in there, and that's based on a lot of case law. It does include the people who are not shrewd, gullible people, who are not wary, the less well-educated people, people who do not have a good facility in English, are not digitally literate or experienced or commercially sophisticated. So all those people have to be put in the class. Also, they thought that the advertisements were particularly striking and would draw consumers to particular aspects. So there was big headlines. They used blue font to draw attention to particular words. Obviously, larger typeface for particular representations and more prominently located. And a big factor here was in the advertisements, there's no mention whatsoever of Employsure. There was no real way of a consumer reading the advertisement knowing that it wasn't a government advertisement. They also thought that the URLs were particularly misleading because they would say to an ordinary reasonable consumer, taking reasonable care of their own interests, that this was a link to the website of Fair Work Australia, the Fair Work Commission, just looking at it. So this is a very relevant factor to the way the representations would have been understood. So they looked at a range of different matters that the primary judge had given weight to, and they identified 7 particular matters which the judge had put a disproportionate amount of weight on in determining whether the representations were misleading. Now, I won't go through these in great detail, but these are the things Griffith put a lot of emphasis on, and they believed disproportionate amount of emphasis on. So firstly, this conclusion that the advertisements were clear on their face as being paid advertisements, which was not really made out by the evidence. Secondly, the allegation that the ACCC overemphasised the fact that Employsure's name did not appear in the advertisements, and full federal court thought that, well, that was actually a very relevant consideration. He put a lot of weight on the fact that the Google ads were different in their presentation to the organic search results, and full federal court believed he put too much weight on that factor. The fact that the ads were in terms directed to employers, although there was evidence that employees had also gone to the site. He concluded that Fair Work had a broad descriptive meaning, which was not limited to particular government agencies, so put a lot of weight on that factor. No evidence that any of the 3 small business owners were misled. So again, looking at individual cases rather than looking at the representation as a whole and forming a view basically objectively as to whether that's misleading. And then this view that reasonable business owners are expected to look after themselves and verify that the information is correct. And that's really not what the Australian consumer law provisions are about. It's protective legislation. So based on all those errors and putting too much weight on factors which were in contention or simply irrelevant, the full federal court decided that the case was made out. There'd been contravention of Section 18, misleading representations about government affiliation, also breaches of Section 29(1)(b), so the quality of the advertised service. Consumers believed it was of a higher standard coming from a government agency. And finally, 29(1)(h), the representations that Employsure had some affiliation with a government department. So the case was remitted back to Griffith to determine the penalty. And the main factors are in relation to the penalty. I guess the first thing is he awarded a $1 million penalty. He refused to grant any injunctions. Now, the ACCC sought a penalty of $5 million, and Employsure suggested it should be between the range of $500,000 to $750,000. One thing to remember, at the time, the penalties were the lower penalties. They've gone up twice since this time, and they were $1.1 million per contravention. Having said that, there were 34,000 individual contraventions. And also, it's important to note Employsure's revenue during the relevant period. This is very significant revenue when you think about it. $217 million revenue, 172 million gross profit. That is a very profitable business, and a profit after tax of 35 million, and that's a very big profit margin. So it is a very, very profitable company. Now, the first issue that Griffith concluded was there was a single course of conduct. He believed that even though there's lots of different ads and they were directed to different, or they referred to different organisations, they conveyed the same representation, and he accepted Employsure's submissions that the impugned Google ads were appropriately viewed as a series of advertisements which had this common feature. So as soon as he concluded there was one course of conduct, he's effectively looking at one penalty for the entire course of conduct. Also, in relation to general and specific deterrence, he concluded that the need for specific deterrence is very low and the contravening conduct was not deliberate. He also had a view that the ACCC claimed the commercial drivers for continuing this conduct were still there, and he said that that was inconsistent with the undisputed facts that the contraventions were inadvertent and the evidence concerning the improved compliance measures which Employsure had put into place, which he gave a lot of weight. So he's concluding that the contraventions which were effectively found by the full federal court were inadvertent. And then finally he notes that by the time the consumer entered into a contractual arrangement with Employsure, they would have known what the truth was. They would have known Employsure was a private company. They would have known there was no affiliation. And they would have known they had to pay quite a bit of money for the basic service. Now, in the amount of loss of damage, there was a big debate as to what was correct, and Employsure provided some information, and on the basis of their calculations, said that the amount of loss of damage was $107,000. The ACCC took a different approach based on the click and call data for the relevant ads and said that the damage arising from the conduct was approximately $10 million. So a very big difference there. It's clear that Griffith seemed to favour Employsure's approach, but he did actually conclude that it was impossible to work out the damage arising from the misrepresentations. He also said that the size of the company wasn't really a very relevant consideration. And he said this comment here that I accept Employsure's submission, which he did quite a lot. He seemed to accept Employsure's submissions in almost every situation and rejected the ACCC submissions. But he says size is not something that can be propounded as a metric for penalty divorce from examination of a contravening conduct, which I guess is true, but I think it's fair to say that he appears to have ignored the size of the company in seeking to set the penalty. So a $1 million penalty in relation to a company with a $200 million turnover is really not going to achieve any specific deterrence. Now, other factors all went in favour of Employsure. He concluded the conduct was not deliberate, it was inadvertent, which seemed to go against the evidence. He concluded that no senior management were involved in the conduct, despite the fact that the managing director had overall responsibility for digital marketing and gave evidence as to the way the whole digital marketing campaign had been arranged. So he seemed to know a bit about it. He said that the fact that there was no compliance program in the business when the conduct occurred was not indicative of there being a culture of non-compliance. He also concluded that Employsure had cooperated with the ACCC despite the ACCC submitting that Employsure had shown limited cooperation. The only issue that I think was clearly agreed between all the parties was that Employsure had no previous contraventions of the Australian consumer law. He also said this thing about parity. He said he accepted Employsure's submissions yet again that the penalty proposed by the ACCC is out of step with penalties imposed in other cases for similar conduct in the relevant period. And there he refers to a number of cases, and he says, well, it's too high because these other cases were significantly lower penalties. And the thing that jumps out at you is the way he's relying on these cases to reduce the penalties, where most courts conclude that looking at other penalties is really a fruitless exercise because the facts are so different. And I think the facts in most of those cases are significantly different to the current case. He did conclude that the range proposed by Employsure was too low and need to be increased, albeit by a relatively small amount. So he increased it basically $250,000 from the maximum that Employsure had proposed. In relation to the injunctions, he considered that it wasn't justified in the present case. The ACCC had failed to demonstrate they serve any useful purpose. Conduct was not deliberate. It's more than 3 years and it's highly unlikely to recur, which isn't a requirement for the grant of injunctions, by the way, but also this was dealt with in a very cursory manner. There's just maybe a couple of paragraphs rejecting the ACCC submissions on injunctions. Then there was a cost decision where he concluded that the respondent, so Employsure, had to pay 20% of the applicant's cost of an incidental to the liability hearing. So they had to pay a very small proportion of the liability hearing despite the fact they lost. And there was also this requirement to repay money to the ACCC because obviously after the first liability hearing, the ACCC had paid costs to Employsure, so they were going to get a small amount of that back, 20% back. But very surprisingly, the ACCC was ordered to pay Employsure 50% of the costs of the penalty hearing, despite the fact the ACCC had won. And the main reason for that was because Griffith concluded that the ACCC had not been as successful in the penalty hearing as they had sought to be. They'd sought a penalty of $5 million. They'd only achieved $1 million. Therefore, they were only entitled to a small percentage of their costs. And which is sort of a strange approach. I guess looking at the liability decision, arguably the ACCC lost a big chunk of that case and didn't appeal it, but ultimately costs do follow the event, and the ACCC was successful in liability and in penalty. So there's another appeal to the full federal court, and the full federal court this time, Reyes, Stewart and Abraham, and they looked at the fact that the ACCC's appeal ground was that the penalty of $1 million was manifestly inadequate and that the cost order as well was in error. Now what the ACCC did, they had an appeal ground which was that the penalty was manifestly inadequate. But then they had particulars, and as you can see the particulars there, penalty fails to bring into account the size of Employsure, fails to take into account the seriousness of the conduct, claiming it's only one course of conduct, doesn't look at the whole period of the contravening conduct. The primary judge said that it wasn't a deliberate strategy. Furthermore, the judge erred in various issues like course of conduct and totality, and finally made an error in relation to costs. Now, the way the ACCC did that wasn't quite correct. They didn't allege all these as separate grounds of appeal, like legal errors by the primary judge. Rather, they include them as particulars to the broader ground that the penalty was manifestly inadequate. And that's not really the right way of doing it. They said the particulars in this case are not even pleaded in the appeal ground. However, the court took a somewhat lenient view and said that they could be taken into consideration, these various particulars, in support of the broader submission that the penalty was manifestly inadequate. But it's probably a little bit of a guide there not to take this approach if you're preparing an appeal against penalty. In relation to totality, the full court concluded that the primary judge had made an error. There was more than one course of conduct. Also, he said in relation to totality, I've applied the totality principle here with a view to ensuring that Employsure is not punished twice for common contraventions. And the full federal court points out that that is not actually the correct way of applying the totality principle. Totality is not directed towards avoidance of double punishment. So effectively, he'd made a mistake in applying that particular factor. Also, the full federal court was of the view that the judge had erred in concluding that it wasn't deliberate conduct. He said that clearly the choice of design was a deliberate conduct by Employsure to achieve a purpose of maximising its benefit. It designed the Google ads to lure customers to Employsure in order to drive up its traffic to its business. And then the obvious point, although the breaches of the ACL were not deliberate, so Employsure didn't set out to breach the ACL, clearly the underlying conduct was deliberate. It was not inadvertent. They clearly designed ads in a particular way to achieve a particular commercial purpose, and therefore the conduct was actually deliberate. So that's a big mistake by the primary judge in assessing the conduct, which has a very big bearing on the penalty amount. So the conclusion that the full federal court arrived at was that the $1 million penalty was manifestly inadequate. It did not adequately reflect the seriousness of the contravening conduct. It was not going to achieve any general deterrence either. So then they looked at what the correct decision should be, and obviously maybe didn't really want to remit it back to Justice Griffith again, so they wanted to replace his decision with their own. So basically they said, properly considered, there were more than one course of conduct. In actual fact, there were 3 courses of conduct, and being one course of conduct for each government organisation that Employsure by its advertisement represented it had an affiliation. And they make the point very clearly. These advertisements reflected separate acts directed at 3 different agencies, covered different time spans. So you cannot conclude that they simply reflect one course of conduct. So that was an error by the primary judge, saying it was one course of conduct. So the second that you've got 3 courses of conduct, you've got 3 events which shall be subject to a separate pecuniary penalty. Furthermore, in the correct decision, they were somewhat frustrated about the approach taken by the primary judge on the role of Google's algorithms. And it was effectively suggesting that Employsure's role in the misleading conduct was limited, because really the blame went on the algorithm. So the algorithm made me do it type of defence. And they were particularly frustrated at this because they said that in their early decision on liability, the full court explained how by paying for a Google ad to appear prominently in the list of search results on a user screen, Google's algorithms will determine the order in which paid results appear at the top of the list. So I guess what they're saying there is that Employsure has responsibility for the way the keywords are selected and the way that the advertisement appears on the Google search site. So it's not appropriate to sort of point the finger at the Google algorithm. Also, the judge concluded that in terms of specific deterrence, it had a lesser role to play, particularly as Employsure had improved its compliance systems. But what the full court was saying, well, Griffith minimised the fact that the company didn't have a compliance system at the time the conduct occurred, and that's something obviously that goes against Employsure in the calculation of penalty. Furthermore, they looked at a number of things that the judge had put a lot of weight on, and he put a lot of weight on this idea of the modesty of the profits generated by Employsure from the ads. And the full federal court found this particularly frustrating because, as I say there, it is difficult to understand how a characterisation of the profit as modest can be made, as the amount of benefit is unascertainable. So as I said earlier, there was 2 different methodologies for working out the benefit to Employsure, and the judge, while favouring the Employsure approach, ultimately concluded that it was impossible to ascertain this benefit. So it seems strange to put a lot of weight on the lack of significant financial benefit to Employsure when there's been a finding that the amount cannot be considered. Quite apart from that, they believe that Griffith had put much too much weight on the idea of the profit generated from the illegal conduct. It's just one factor that has to be put in the instinctive synthesis, and here Griffith was placing much too much emphasis on the role of actual or measurable profit in assessing the conduct as a whole. Furthermore, there was this very strange development where there was agreement in the declarations that the conduct had occurred for a couple of years, but then before the primary judge there was some evidence submitted that suggested that the conduct had only occurred over a 10-month period, and the judge seemed to put weight on that new evidence and concluded that the conduct had gone for a much shorter time. I think this particularly annoyed the full federal court because the evidence was entirely unsatisfactory. You cannot use evidence brought in at the penalty stage to reverse a declaration which has already been made by the court, which says that the conduct went for 2 years and which was accepted by the respondent, Employsure, as being accurate. So for the judge to sort of suddenly say, well, the conduct only occurred over a 10-month period when there was a declaration stating that it went for 2 years was just really inexplicable. Furthermore, they made the point that this is serious stuff. Companies making misrepresentations that they have government sponsorship approval is a very serious breach of the legislation and must be deterred. That's a very strong argument that the courts need to impose significant penalties for this conduct. And they make the point that ordinary small business owners are entitled to rely on the belief that the Commonwealth government organisations exist, as well as state and other government organisations, to serve the public good, not to make a profit, as was the case with Employsure, which made the representations that its services had government sponsorship approval. It misled people about the standard of its services. So this is important stuff and meriting a significant penalty. They also said that the correct amount that should be imposed as a penalty is actually $3 million, and that this amount would satisfy the requirements of reflecting the seriousness of the contravention, satisfy the elements of deterrence, and would contain a sufficient sting to ensure that Employsure doesn't see, and not just Employsure, but other businesses will see it not as simply a cost of doing business. Now, turning to the cost, so they replaced the $1 million penalty with a $3 million penalty, and now they've turned to the cost issue, and they simply conclude that there was no basis for the cost orders made by Justice Griffith. As they said there's High Court authority, that the successful party is entitled to their cost, and that should not be altered. There was simply no proper basis to order that the appellant, the ACCC, pay 50% of the respondent's costs on the liability hearing when the ACCC won the penalty hearing, when they won that hearing. So the primary judge clearly erred in the exercise of the discretion in relation to costs, and there was simply no material before the court to suggest the ACCC did the remittal penalty hearing in a way that deserved any condemnation. Clearly a hearing was necessary, and it had to be a hearing to determine what the penalty had to be. A substantial penalty was actually imposed, and the litigation was conducted appropriately by the ACCC. So there's no reason to punish the ACCC by not giving their costs. So that was reversed as well. They concluded that Employsure should be ordered to pay the ACCC costs of incidental to the remitted penalty hearing, and that was something that was overturned, and that's a rare thing, to overturn a cost discretion decision. And just a bit of commentary there, it's a very unsatisfactory approach which Justice Griffith took to this case. He made a number of conclusions about a part of the ACCC case which was quite strong, and did not follow the guidance of the full federal court when coming to the penalty decision. Clearly, when he got the full federal court decision on liability back, it was clear that this is serious conduct deserving of a significant penalty, and yet that guidance appears to have been ignored and a very low penalty has been imposed. It looks to me like he's misapplied the law in many respects in relation to totality, in relation to defining the relevant class of people, who's in the relevant class of consumers, also the importance of looking at representations objectively, the relevance of intent, whether conduct is deliberate as opposed to a deliberate breach of legislation as opposed to deliberately engaging in conduct which constitutes a breach of legislation. So many problems there. Also in the way that the cost judgments were determined, there are problems in relation to that. It seemed to me that Griffiths was really overwilling to accept all the Employsure submissions and simply to reject all the ACCC submissions. It seems a bit of a pattern that he would adopt all the Employsure submissions and their evidence and just reject everything the ACCC put forward. Now, I think the ACCC's initial case was quite weak. Clearly the government representation case and the design and keyword cases, so the first two causes of action were quite strong, but then they threw in this strange case about free representations which really had no merit, and I think it is a commercially naive argument to put that customers and companies can't offer a free service with a view to trying to win some paid business. It's a very common feature. Many businesses do it, including the legal profession. There are many lawyers who offer a free initial consultation, and clearly the purpose of that is not to do some pro bono work. It's clearly to provide some free advice with a view to winning the customer over to become a paying client. So if that's going to be illegal, a lot of companies are going to get sued by the ACCC, including large sections of the legal community. The ACCC really should run tighter cases. The unconscionable conduct case was very weak, I thought. It seemed to be suggesting that if you mislead consumers, that could be unconscionable. Clearly that's not going to work. Also putting on statements that the evidence contradicts recordings that are in the possession of the respondent, something that should be avoided, or should be provision should be made for that not to happen. So really it should run tighter cases. I thought the unfair contract term case looked quite strong. And I'm surprised they probably didn't appeal that particular aspect of it. I think, as I said earlier, the free offer allegation shows a real lack of commercial understanding. One issue that sort of hit me was whether remittals after a liability judgment should really go back to the same judge or to a different judge, because some judges are so invested in their initial decision that once the decision comes back to them, they may be a bit reluctant to, I guess, impose a big penalty. And so I think there might be an argument that if a case is appealed to the full federal court and there's found to be problems in relation to liability, that it get remitted to a new judge who can use the guidance of the full federal court. They're not invested in the initial decision, and maybe they'll make a better decision. So I guess that's all I had. It's an interesting case. I think there's a lot of law in this, a lot of important law about the way misleading deceptive conduct is to operate, as well as the proper approach to determining penalty. So I think it's well worth being aware of what was decided in the case. So I guess if you have any questions about this, the closure of the Employsure case, let me know. You can either send me an email or give me a call. Bye-bye.